Final moments of Donald Trump's civil fraud trial are playing out right now in a New York courtroom, a trial that cuts to the heart of everything that Donald Trump has built his name on. The New York Attorney General, Letitia James's office, is finishing up their closing arguments right now. They are trying to make the case that Donald Trump and his adult sons, Donnie and Eric, and their company defrauded banks and insurance companies by lying about the value of their assets. The New York Attorney General wants Trump to pay $370 million in fine and for him to be banned from ever doing business in New York State again. The judge, we should note, has already found Donald Trump liable on one of the 7 counts. Trump's team has rejected all of the claims of fraud from the very beginning, and they're alleging without proof that Donald Trump is being prosecuted because he is running for office.
A judge sitting in that courtroom looked Donald Trump straight in the face and told him to stop talking, and that was the moment the whole performance started to break down, not because the judge was unfair, not because the case was staged against him, but because Donald Trump, a man who has spent nearly 5 decades using confidence, repetition, and public performance as a form of power, had entered one of the few rooms in America where none of that counts as evidence. That is what most coverage failed to capture about what happened inside Arthur Engoron's courtroom. Once you see the moment clearly, it becomes impossible to look at it the same way again. This was never only about courtroom drama. It was about a man's personal mythology finally meeting a legal institution that refused to accept performance as proof. Now let's see why this was never just about balance sheets or bank fraud.
Donald Trump has a much diminished sort of empire and has lost all of his licenses to conduct business in the city of New York. That's an existential threat to the Trump organization and the Trump family's enterprise over the course of his life. And really, more importantly, maybe even to him, why you see him looking so angry in court, to his personal identity, to everything he said about himself since he was a young man, that he built a massive empire entirely on his own. That in itself is not true either, but it's really important to him to hang on to that. And it's the argument that he makes over and over again to his supporters in the political realm as to why he has the sort of expertise and experience to be president.
I study power, especially what happens to people who have lived with it for so long that they forget what limits feel like. And what happened in Judge Engoron's courtroom was one of the clearest psychological portraits of Trump under pressure. On the surface, the case was about inflated balance sheets, exaggerated asset values, financial statements, and allegations of bank fraud. But beneath the legal language, something deeper was happening. This was about Donald Trump's lifelong relationship with the image he built around himself, and what happens when an institution finally refuses to bend around that image. Most of the coverage focused on the loudest pieces of the day, the clash, the speeches, the judge interrupting him, the walkout, and the press conference. But those moments were not simply a loss of control, they were part of the method, and the key question is what that method is going to cost him. This next part shows why the judge's warning was not just a lecture.
And the judge had to try to rein him in, telling Trump's attorney then, you need to control your client or I will. So the judge saying, if Trump won't agree to these terms, he's going to cut him off. He's not going to let him speak. And if he violates his gag order, he's going to have him escorted out of the courtroom and fined no less than $50,000. So Trump's team saying that he would not agree to these terms, and the judge having extended this deadline for them several times because they were having some issue getting in contact with Trump. He said ultimately, take it or leave it, now or never. Trump's team had until noon today to respond. They did not. So at 12:12, the judge had informed Trump's team by email that he's not expecting him now to speak because he did not agree to comply with these terms.
When the judge warned Trump, it was not just a lecture. It was not just a courtroom scolding. It was the judge building a record for the penalty phase. That warning had legal force. The judge was making it clear that the way Trump behaved on the stand could affect the punishment, not in some abstract public relations sense, not just in terms of credibility or optics, in real money, real assets, and real consequences. Trump's lawyers could not stop it. In fact, they admitted they could not guarantee it would not happen again. That admission mattered because it showed the court something important before Trump even finished damaging himself. His own lawyers could not promise that he would follow the most basic rules of testimony. Now watch what Trump's own lawyers admitted before the court.
How to mount a winning defense for the twice impeached, 4 times indicted former president who has a penchant for suddenly demolishing his lawyer strategies by making ill-advised confessions. What must be causing his lawyers a lot of heartburn is the fact that Trump has claimed numerous times in the past few weeks that he is ready and willing to testify under oath during his trials. Well, it's okay, Trump lawyers. There's nothing to worry about. Let's not forget what Trump claimed back in 2015.
This is a continuation of his confessions tour. He contradicts his prior statements. He contradicts his lawyers constantly.
Think about how serious that is. A legal team stood before a judge and could not say with confidence that its own client would answer yes or no questions with yes or no answers. That is not a small discipline problem. That is a signal of what the lawyers already understood before the hearing began. Trump does not easily place himself under authority unless he believes he controls that authority. But in that courtroom, he did not control it. The judge did, the record did, the rules did. Here is where the entire case changes because the fraud finding was already settled.
But in looking at the summary of this ruling, we see in addition to the monetary penalties that Kara just laid out, they have found him liable for fraud, and they are going to continue the appointment of an independent monitor. So back in 2022, the judge installed a monitor to keep an eye on exactly what the Trump organization was doing when it came to its business dealings. Now, among the things this monitor uncovered were a $48 million loan, for example, to the company itself, but there was no paperwork. They couldn't really find any information. That was just one thing that came up. Now, Trump lawyers have insisted because they loaned the money to themselves, they didn't have the paperwork that they needed, and insist that the monitor has found no fraud. Now, the judge also here orders the installation of an independent director of compliance. But I also want to note that they are saying here, the judge is saying that they're going to limit the defendant's right to conduct business in New York for a few years.
And the judge had already established the core facts before Trump took the stand. This is the detail that changes the entire story. Trump was arguing innocence in a courtroom where the judge had already ruled in writing that fraud occurred. The proceeding people watched was not about whether fraud happened. That question had already been answered. The proceeding was about how much it would cost him. That is not a side point. That is the structure of the whole case. The fraud finding was settled. The remaining question was the penalty, the number, and the level of consequences. Now let's see how Trump turned the penalty phase into a grievance speech.
He refers to the trial as a scam, a rigged trial. He says he would have loved to have testified. He could have testified. It was his decision not to testify. He said, quote, "I would have loved to have testified." And then he went after some of the witnesses, including Michael Cohen, for example, potentially a violation of the gag order that has been imposed by the judge against him. Aaron, we're going to continue to listen to what the former president has to say, but clearly, without a teleprompter, he's going off the cuff. He's railing against almost everything.
That is why Trump's closing argument became such a defining moment. There was a gap between what Trump kept saying and what the court had already decided as a legal fact. The judge had already ruled. Trump knew it. His lawyers knew it. So when he was given the microphone and turned the moment into a grievance speech, the choice became clear. Either it was an incredibly reckless legal move inside a Manhattan civil courtroom, or it was a calculated performance for an audience outside the room. When Trump got the microphone, after the judge had resisted giving him that chance, he immediately called the case politically motivated. But he did it in the same courtroom where the judge had already issued a written finding that fraud occurred. The hearing was about the price, and Trump spent it making that price more dangerous for himself. That contradiction was not random. It was the story. This was not just a defendant losing his temper. This was a legal system dealing with someone who seemed to believe the rules of evidence were written for everyone else. And now the institution was showing him what happens when patience ends. The structure of the case matters because much of the coverage blurred it. New York Attorney General Letitia James filed a civil complaint alleging that Trump, through his companies and personal financial disclosures, systematically inflated the value of his properties and assets. This was not described as a tiny rounding error or a normal disagreement between appraisers. The allegation was that the overstatements reached into the billions. Judge Engoron reviewed the evidence and found before the penalty phase began that the fraud had happened. That finding was not successfully removed. It was not tossed aside on a technicality. It remained in the public legal record as an established fact. A simple example makes it easier to understand. Imagine someone tells a bank their house is worth $2 million when every independent appraiser says it is worth $400,000. The bank lends money based on the inflated number. Later, a court determines that the representation was false. At that stage, the trial is no longer about whether the person lied to the bank. That has already been decided. The trial is about the consequence. That is the stage Trump was in when he gave his 5-minute grievance speech. He was not there to prove innocence. He was there during the penalty phase, and he spent that time increasing his risk. The judge's warning about negative inferences was not just frustration, it was a specific legal mechanism. In a civil case, if a defendant obstructs testimony, avoids direct answers, or refuses to respond properly under oath, the judge can treat that behavior as evidence that the honest answer would be damaging. In simple terms, when someone under oath refuses to answer a yes or no question with a yes or no, the court may conclude that the truth hurts that person's case, and that can be considered when calculating penalties. 4 things matter most. First, the fraud finding had already been made before the hearing started. Second, the remaining issue was the penalty, not guilt. Third, Trump's behavior on the stand made his exposure worse, not better. Fourth, his own lawyers told the court they could not control him. That last point is extremely important. Any defense lawyer watching would know how damaging it was. Trump had just created an on-the-record demonstration of why a harsher penalty could be justified, and then he left before the afternoon session. This was not only Donald Trump versus Arthur Engoron, it was Donald Trump versus the idea of judicial authority itself. What happened in that courtroom was part of a pattern that has followed him for decades. Trump has attacked judges throughout his public life, not only Democratic judges, not only judges in cases he lost. He has even attacked judges he personally appointed the moment their rulings went against him. You see the same pattern in the E. Jean Carroll case, in January 6th related proceedings, in immigration cases, and in other legal battles where the system refused to give him the outcome he wanted. The pattern is simple. First, Trump enters the process as if he is participating. He appears, files motions, shows up, and takes the stand. Then, when the process refuses to validate his preferred version of events, he stops respecting the rules. He gives speeches instead of answers. He treats procedure like persecution. Then he leaves the institution and attacks it from the outside. He holds a press conference, attacks the judge personally, attacks the prosecutors, and tells his audience the whole thing was rigged from the start. That is exactly what unfolded in New York. Trump showed up. He testified. He gave speeches rather than direct answers. The judge cut him off. Trump did not return for the afternoon session. Then he walked outside and attacked the judge, the attorney general, and the trial. But that press conference was not simply a reaction to what happened inside. It was part of the plan. This is something institutions still struggle to understand about Trump. He does not use legal proceedings only to win legal cases. He uses them to create political content. The courtroom becomes the set. The press conference outside becomes the real show. That is why the zipped lips gesture outside the courthouse was so revealing. It looked like a promise of restraint, but it was really a piece of content. He knew that once inside, he would likely turn the proceeding into a speech and force the judge to cut him off. The gesture and the rant were not contradictions. They were two scenes in the same production. One was for the photograph, one was for the clip. One was for supporters who wanted to see him restrained. One was for supporters who wanted to see him defiant. What you were watching was a media strategy dressed up as legal defense, and the legal price kept rising. The stakes in the room were enormous. The penalty was not just a small fine or a symbolic slap from a regulator. The Attorney General was asking the court to impose restrictions that could affect Trump's operational control over his New York business structure. This was about more than a dollar amount. It was about the Trump brand itself, the organization that has been tied to his identity, his leverage, and his business life for decades. Then Trump layered his own testimony on top of that risk. He told the judge the proceedings were boring. He called the trial a fraud against him. He accused the Attorney General of acting politically. Every one of those statements, made on the record during a penalty hearing, sent the wrong message. Judges consider remorse, acknowledgement of wrongdoing, and whether the conduct is likely to change. Trump showed none of those things. No remorse, no acknowledgement, no sign that future business practices would change. With each statement, he seemed to support the argument for a harsher penalty, and one of the most important details received far too little attention. All of this happened on the same morning police responded to a bomb threat at Judge Engoron's home. This was not some vague security concern. It was a bomb threat at the judge's private residence. Engoron still drove to the courthouse. He sat on the bench. He ran the session. He issued warnings. He told Trump's lawyers to control their client. He enforced the rules of his courtroom on the same morning someone had threatened his home for doing exactly that. That detail tells you more about the pressure on American legal institutions than any headline about Trump clashing with a judge ever could. What Trump revealed in that courtroom was not just contempt for the law. Contempt suggests a person understands an authority and chooses to reject it. What happened looked deeper and more automatic. Trump spent nearly 50 years in rooms where his word often became the dominant reality. As a developer, he controlled the building. As an employer, he controlled the workplace. As a television figure, he controlled the set and delivered the verdict. In those rooms, his narrative often won because he controlled the environment and the exit. A courtroom reverses that power structure. Trump does not control the exit. The judge does. He does not define the story. The evidentiary record does. He does not get to decide which questions matter. The court does. He cannot replace answers with speeches without consequence. If he refuses to answer, he can pay more. What Trump appeared to expect was what had happened in so many rooms before. That volume, repetition, confidence, and force of personality would eventually make the room give way. But this room did not give way. When the judge told his lawyers to control their client, it was not just a procedural warning. It was a moment Trump seemed unfamiliar with. A room that would not bend. that reveals something larger about the world Trump has operated in. Celebrity, money, and political power had often shielded him from the kind of authority ordinary people encounter all the time. Most people who have ever been on a witness stand understand that they must answer the question asked. That is not complicated legal theory. It is the basic reality of sworn testimony. Trump's surprise at being held to that standard showed how rarely anyone had drawn a line with him and refused to move it. This pattern is likely to repeat because the press conference strategy worked politically. By the time many people heard about what happened inside the courtroom, the dominant story had become Trump versus a biased judge, not a defendant increasing his own penalty risk with every evasive sentence. Inside the courtroom, the institution held the line. Outside the courtroom, the narrative battle moved in Trump's direction. A useful way to understand it is to imagine a chess player who has always been allowed to move pieces after placing them down. When someone finally tells him the move is illegal, he does not experience that as the rules being enforced. He experiences it as an attack. That is the psychology that seemed to unfold on the stand in New York. This matters not just as political news, but as a structural test of how American institutions operate under pressure. The civil fraud case established something major, that much commentary buried under the drama. A former president and active presidential candidate was found by a New York state court to have systematically deceived financial institutions, not merely accused, not just alleged, found in a written ruling on the public record, and the consequence of that finding was being decided in a hearing where the defendant could not follow elementary courtroom procedure. The international business implications are also serious. Every bank, insurance company, lender, or institutional counterparty considering future business with Trump can now review a public court record stating that his financial representation were found fraudulent. That is not just a vague reputational issue, it is a legal document that due diligence teams anywhere in the world can pull before signing anything connected to Trump's name. The financial ripple effects may last for years, no matter what exact penalty number the judge imposes, and the bomb threat should stay in the center of the story. When people talk about the health of democratic institutions, they often speak in abstractions. Norms eroding, guardrails weakening, trust breaking down. But what happened that morning was not abstract. A judge's home received a bomb threat. He went to court anyway. He ran the session. He held the line. And the defendant, whose business future depended on that courtroom's continued function, spent the morning attacking the judge's legitimacy, first inside the courtroom and then outside at a podium. That is why the negative inference warning matters so much. It was not rhetorical. The judge was constructing a record. What comes next is not just a number on a penalty document. It is a test of whether civil courts can impose real consequences on defendants whose fame, wealth, political power, and public following have often pushed them beyond ordinary accountability. The first major point is that fraud had already been established before Trump spoke on the stand. That is the foundation of the entire story, and much of the coverage did not explain it clearly. The speeches, the clash, the judge cutting him off, the walkout, and the press conference did not happen during a guilt hearing. They happened during a penalty hearing. The judge had already ruled that Trump committed fraud by overstating his net worth to banks and insurers by billions of dollars. That finding was the starting point. So when Trump declared himself innocent, he was making a political statement in a room where the legal question had already been answered. The second major point is that his lawyers could not control him, and they told the court that directly. When asked whether they could guarantee he would answer yes or no questions properly, they could not. That was not a clever strategy. It was either a serious breakdown between lawyer and client, or a sign that Trump was going to do whatever he wanted regardless of legal advice. Either way, it was damaging. Either way, it became part of the record. Either way, it spoke to whether the defendant respected the proceeding and whether he could be trusted to comply with future court orders. The third major point is that the press conference outside was not a reaction to the courtroom. It was part of the plan. Trump entered the courthouse with two audiences in mind. One audience was inside, the judge, the legal record, the proceeding. The other was outside, the cameras, supporters, and political base. The conduct that harmed him legally helped him politically. The speeches, refusals, and walkout increased his legal exposure, but they created the defiant political content his audience wanted. That trade-off is not going away. It will likely appear again. The fourth major point is the image of Judge Engoron still running his courtroom after a bomb threat at his home. That is the picture that matters most. Not the press conference, not the spectacle, not the political noise. A judge was threatened and still showed up. The courtroom still functioned. The rules were still enforced. That is institutional resilience in real life. Now the next thing to watch is the penalty. If Judge Engoron issues a penalty large enough to threaten the Trump Organization's operations in New York, the real question will be whether the penalty is enforced and how long enforcement takes. The gap between a penalty being ordered and a penalty actually being collected will show whether the consequence is real or just procedural theater. Also, watch whether Trump's conduct on the stand appears in the final penalty reasoning. Judge Engoron warned in open court that Trump's behavior could draw negative inferences when calculating the penalty. If that language appears in the final order, the warning was real and it was used. If it does not, then the question becomes why the warning was placed on the record but not followed through. That answer will reveal something important about the limits of civil courts in a moment like this. And the biggest question remains unanswered. If the penalty is strong enough to threaten the Trump Organization's existence in New York, what does a man who has tied his identity to his buildings, his brand, and his image for his entire adult life do when one of those pillars is taken away? We do not know the answer yet, but the courtroom moment you just watched is where that answer begins.